Thank you. So our attorney has prepared the resolution for this application for hearing approval. Hannah, do you just want to go over the highlights, please?
Yes, so the board should have a slightly revised version from what was previously posted on Friday on the website. Just a couple changes for clarity and to be more concise on a couple things. The first section is just the history of the board's review of this project. I want to note a slight change on page 5. I have a whereas clause, just further explaining how the applicant offers to donate a portion of the land comprising the project to serve as parking, to serve the community, but also specifically recognizing the need for parking near the Falcon. So that's now included as a whereas clause on page 5. Starting on page 9, I went through each of the county comments and then the board's responses to those comments, beginning on page 10, some of which, as we know, the board voted to adopt as conditions of approval, which now are included as conditions, and some of which the board chose to override or act in contravention of the county's comments. I would note, as is mentioned on page 13, the board will be considering preliminary subdivision approval. I know in the past the board has moved on certain lot line changes to jump straight to final approval, and there is a provision in the code which provides that if there's a lot line adjustment or consolidation of 2 or fewer lots, the board can both waive the public hearing and issue one single as opposed to separate preliminary and final approvals. This project involves, Mark, is it 3 lots?
Yes.
And so the applicant has agreed to move forward just with preliminary for now, and will come back for final approval. That could happen as soon as the next meeting, but will just depend on however they choose to move on that. And I will note too that if there is a 2-step, like in this case, if they come back with a final lot line plat that is identical, or I believe the wording is substantially similar to the preliminary plat, then you can choose to waive the public hearing on that. So that could be a really quick wrap it up kind of situation at next month or shortly thereafter meeting. There's a whole slew of conditions that I've included with the help of Pat, thank you Pat, beginning on page 13. These include rec fees, payment of other fees in escrow, a stormwater facility maintenance agreement. I included in that section the requirement for performance security in an amount and form required by the code. This could but doesn't need to be in the form of a bond. The planning board has the authority to decide that it would like to see a bond, but it doesn't require that in the code. So I just said in an amount and form required by the code section. I think that probably will be sufficient. In condition at 5, there are other easements required, one of which will be for emergency access across the wastewater treatment plant parcel. We discussed, one of the county comments was as to signage. So I included signage as a condition, as well as, I believe on the subsequent page, we discussed non-reflective and earth-toned colors to further mitigate the visual impacts. There are other discretionary permits and approvals required from the DEC, the Department of State, the DOT, the Department of Health, the Department of Law. There will need to be filing of a condominium offering plan.
I'm sorry, could you just repeat that again?
Department of Law. Filing in the Department of Law of the condominium offering plan, which will include as a special provision the proximity of the property to the wastewater treatment plant and notice thereof. In part F3, there's to be the offer of dedication of property to be used as the municipal parking lot. We discussed that. And I included a time provision, as this board has chosen to do in the past, to require that these conditions be satisfied within 6 months. And then, the only other note that I would have is that, the chairman can sign these maps upon the completion of all these conditions.
Thank you. Council, question from the board?
Check the conditions.
No.
Who's responsible for that?
So Hannah, most of the conditions that we have are more legal than physical, correct?
Yeah, plan revisions are required, outside agency approvals and the legals. So typically, we use this as a guide, and once those are all done, my office will do a letter to Jen stating the condition and how it was resolved.
Okay. And what about the bond? Should we consider a bond? Sounds like it's something.
That'll be worked out through my office.
Any other comments or questions from the board? Did you have anything, sir?
We have, I have one concern, and I have a question. Let's do this first. I raised this with Hannah this afternoon at the 11th hour. I apologize for the late notice, but if we could go back to the page number 10, it's the first condition. It's the first response to the County of Ulster responses. When the board,
Which number are you referencing?
we're at number 1. I have a little bit of an older version. I'm on page 10, but it's the planning board determined at its September 15th meeting as follows, and number 1, if you can follow me down to the second sentence, if adjacent parcels,
Hold on one second, because that's not my page.
okay, I'm sorry, it's the first response to Ulster,
It's the last line on page 10.
Okay.
okay. So if you continue into page 11, you'll see the second sentence and the third sentence. Beginning with, if adjacent parcels with frontage on 9W are developed. And then the second would be the third sentence. The planning board is satisfied that such a connection will be the obligation of the future applicant. So, we thought about this, these two sentences over the weekend, and here is the concern. We're asking that those two sentences be deleted, and here's why. That concept of the cross easement is the board, these two sentences recognize that concept on a future applicant and really a future owner. The owner of that commercial parcel would have to seek a easement from the condominium. So it's a burden on that future owner. That burden remains, whether this comment is in there or not. That future owner has that burden. As per the application they bring, they may trigger that they may need an easement from the condominium. But in the offering plan for the condominium, in terms of it for its disclosure, the condominium would then have to disclose to future buyers this potential. And this potential may never be realized. So it severely diminishes, or could potentially severely diminish the offering, the condominium value, when it's really the obligation of a future applicant and a different owner. So it doesn't diminish your jurisdiction, doesn't enhance your jurisdiction. It's really just it's a recognition of an obligation, but on a different owner. It could potentially hurt the offering plan. We're asking, since it doesn't hurt or enhance the board's jurisdiction, we're asking that those two sentences be deleted.
Hannah?
So, yeah, I think the reason that we included this is because it directly responds to the county comments. And if you flip back to page 9, the comment from the county was that the county planning board further recommends cross-access easements along the parcels owned by the applicant fronting Rt.9W. So this response was based on the board's discussion of that county comment and saying that if there are to be cross-access easements, recognizing that that would be the obligation, as Mark said, of the adjacent property owners if they so choose to develop with commercial or whatever it is along 9W. So I agree that on the one hand, this isn't actually speaking to any obligation of this applicant. It's just saying that if there are to be cross-access easements, it will be in fact the responsibility of some future applicant. So that is true. And I will say that I have not worked directly with condominium offering plans, but I don't really necessarily see how stating that there is a potential for some other adjacent property to request a cross-access easement of this applicant would be detrimental to the property value of the parcels. But that's maybe perhaps because I don't know
Right.
realty law.
And I would just point out, I'm sorry.
No, that was it.
So, and the county comment was based in an incorrect statement that the county was incorrectly thinking that it was, all those parcels are in common ownership. So I think what this statement does is it clarifies, it says that the board did identify that issue. But putting the obligation on a different owner for potential future project is something that it's just cleaner and it's better immensely better for the condominium offering plan if this isn't in there. It's not an obligation on the condominium. We're just asking that to be deleted.
And do you see an issue with that thing?
I don't see an issue with it. I think that ultimately the effect will be the same, whether this language is included or not. The effect will be if there is future development on adjacent parcels, then this board will know, county is likely to say they need cross-access easements, and they'll be in the same spot as they would otherwise be with or without this language. They'll just go to this applicant and say, can we have an easement, yes or no? So I don't think it would be harmful if the board removed this language.
Any objection from the board?
Just, I'm sorry, it's hard to hear you since you're on the microphone.
Oh, yeah.
And I'm just hard to hear. I'm not really that hard to hear. Just a little hard to hear. But, so, these are two separate parcels that we've obviously talked about. And the, having at all any possibility of having an easement from something that's a future development could be, let's just go to crazy, it could be a cannabis shop. And then forcing that onto the easement from, with the road that comes in off of 9W to the residential would be a horrendous thing to happen. So they're two separate parcels. When we do come forth with a plan for the commercial property, it'll stand on its own. And there should be no relationship, no mention of any potential easements between these two properties.
I think we're good.
We agree. That's right.
I like to hear myself talk.
Yeah, I can, because in our discussions about this before, and we have to make the case as a planning board that we've considered what the county has asked us to consider. And in those discussions, even though you guys were not willing to consider looking at this immediately, because you were insistent that there could be future owners, it was my understanding that it would be put into the records that we were looking at cross easements if that commercial property was ever further developed, because we have to do that under our comprehensive plan, under our Rt.9W corridor study, under complete streets. The county is asking us to do it as well, and to act like we're not taking that into consideration and making that a part of the record through the resolution, I think is being remiss in doing what we're supposed to do as a planning board.
But I respectfully submit, I believe you have done that. The first sentence of that response does acknowledge that reviewing a hypothetical potential speculative project, or pulling obligations out of a hypothetical speculation and putting it as an obligation, it's really not the board's purview to do that, and they're acknowledging you're not doing that.
No, the reason that we didn't make you do it now is because you felt that it was so speculative. But we're acknowledging that in the future, in order to do the planning that we're responsible to do and have less access onto Route 9W, any future development is going to have to consider these cross easements. So,
But that's on the future development, a separate owner, a separate project. That mention burdens us, burdens the condominium offering plan.
well, you
It's
can bring that
economically
up when
detrimental.
the discussion on this.
Excuse me?
you said that, you never brought that fact up when we had the original discussion on all this.
It's two different things, it's two different things. We acknowledged, on the record, we acknowledged that a future applicant, a future owner, might have to come to the condominium and ask for an easement. We've acknowledged it. No one is retracting that acknowledgement. All I'm saying now is that from a drafting standpoint, when we look at this language, which places a detriment on a current owner who's coming forth with a project, it doesn't enhance, it doesn't diminish. This language does nothing for your jurisdiction. Your jurisdiction remains the same. The obligation on the future applicant remains the same.
And that was essentially your point as well, that these things would have to be taken care of regardless of whether someone's in it or not, by the next applicant.
Right, the question isn't as to jurisdiction. I think the point that Cindy is making is that it does make the record fuller and explaining the planning board's reasoning for its response to county. I think that's true. That having these sentences that say, yes, not only did we review the concept of cross-access easements, but you made some kind of determination as to how they would fit into future planning, I think is correct. I guess my main question would be, I'm not sure how this could negatively impact the applicant, especially because the statement isn't that this parcel would be subject to an easement. It would be that some other future applicant, it would be their responsibility to request of this applicant an easement. So it's not saying that this land is presently burdened by this.
Right, no, I agree with that, but we have to disclose that. The offering plan would have to disclose the mere possibility. And the mere possibility that may never come to fruition will have a discernible impact. So the condominium offering plan is going to be impacted negatively by this disclosure.
You think fewer people will buy because of this?
We think it's gonna hurt the price point, yeah. No, I mean, it's not a number of purchasers, it's going to, look, we're trying to maximize value and maximize the benefit it also maximizes the benefit to the town. And so from our perspective, this sentence, the deletion of these two sentences doesn't delete the obligation to the future owner, but it potentially hurts us after, we're asking for it to come out.
We met the requirements of the DOT, and that is really the most important part, and also the highway and safety department of this town. So to obligate an easement that is not necessary or not ordered so by the DOT or anything else like that. We made the lanes wider, we made the entrance gates longer so that we could have more traffic build up there. So we did everything. So to again, even mention an easement and you contravened, or what's it called?
Acting in contravention.
Contravention. You've contravented, that's the right word, but if you've contravented, there's so many other things here. Now to hang your hat on, well, we can't totally contravent this thing, is I think a little crazy, because you contravented 15 other Ulster County things. Thank you for that. But the same thing with this, if you contravene this at 100%.
Each of the others we explained, but regardless, is there a motion to exclude those two sentences from this page 11?
I'll make a motion.
I'll second. Any discussion?
So then it's not a defensible situation, with the present consideration that we discussed these things, it was agreed to, and now in a sense, we should add a little bit of an addendum saying, well, we just found out this might affect the applicant's bottom line, so we've changed our mind.
I suggested that we just remove the first of these two sentences at issue and leave the latter, which would be the planning board is satisfied that that would be cross easement would be the obligation of a future applicant. Would that be a satisfactory compromise?
Well, but that, recognizing that the planning board, the cross easement issue then has to be disclosed.
Either way.
Yeah, so, because you have to disclose the possibility to within the offering plan, so that the potential buyer sees that. That's what since it's speculative, that's why we're asking for it to be deleted. The full county comment is in here, and your full response is in here. We're just trying to clean it up for this sale.
I mean, that would be the basis for the planning board making a determination whether or not the applicant can make more or less from its sales. I don't think it's one of your considerations, but I think that the board has the authority to vote whether or not to exclude these sentences. And, you can make that determination on the dais.
So there's a motion to exclude those, two sentences. All those opposed?
Aye.
Aye. All those approve?
Aye.
Aye.
Aye. So, 1, 2, 3, 4, that goes. So we will strike those two.
And then, Mr. Chairman, the second comment that we had was in reviewing the conditions and speaking with our engineers today, the 6-month timeframe we believe is too short. And, for these conditions to be met prior to, I was a little confused, prior to the issuance of the building permit or prior to the?
Stamping of the plan. And that's why we included that you can get an extension of up to 2 years. You could come back with an application to ask for an extension.
I'm sorry, just for me, could you explain what the timeframes are exactly? 6 months from what to what?
6 months from this approval,
Yes.
then all the conditions will be satisfied.
Okay, where are the conditions starting?
But it has provisions for extension, the town code allows for 2 years.
I appreciate that, I just wanna know what I'm getting into, so 6 months for all the conditions, where do they start, where do the conditions start?
Beginning 14, I believe,
You would say
or 13.
All these,
no, yeah, yeah.
so all these have to go within 6 months?
Within-
Or
we
extension.
come back and grant it.
And we have to come in from the planning board for that?
Planning board grants it by motion, yes. Is that right?
Yeah, typically you give an update on all the conditions at that time.
Excuse me?
Typically you give an update on the conditions at that time. We're waiting for DOT, we've made submission to the health department, so the board sees that there's progress being made towards the conditions.
So it's like 6 months we come back and provide status.
Okay. At a maximum of
Well, the
a
code,
2-year extension, so it's 2 years.
the code has provisions for 2 years from approval that you must obtain a
Okay, 6
building.
months, and then you have.
You must obtain a building permit within 2 years or this approval lapses.
No, they have 1 year to get a permit, and then
Right.
2 years, no, 1 year to start, 3 to finish, and then they have 3 extensions.
So, and also,
Yes.
okay. Can the building, only the building permit be extended also? And
That's
how-
what the
That's the
building,
2 years.
Excuse me?
that would, to extend the permit.
No, for permits, after you get a building permit with the building department, but you have a time frame here that adds up to, I think, 2 years. You can get, it's 1 year with a 1-year extension, and then to get a building permit. And then your building permits can be extended through the building department.
Okay.
The clarification is if we extend, let's say we come back in 6 months and we extend this, then that obligation, that 1-year obligation to pull the building permit is really de facto, that's extended as well, because this approval is extended. That's it.
Yeah, but within 2 years, you're gonna have to have it complete. So you
Have the building permit.
have a building permit in hand.
Right.
Okay, all right, that's very livable.
And that's town code.
Yes.
So, divine amendment to the resolution, the planning board of Marlboro, planning board, planning board of the town of Marlboro offered the final resolution. Officer Brandt offered the final resolution, which was seconded by member Lamel.
I'm sorry, just give me 1 second, I'm sorry.
Sure.
without tearing it down. So it'll be really the beginning of construction, March, I imagine, would be the start date. But again, it's just an estimate, you know, we're going for financing and the rest of it. Sorry for
So as the resolution goes with the amendments, Chairman Brand is yay. Lanzetta?
No.
Rivera?
Yes?
Callan?
Yes.
Jennison?
Yes.
Lamella?
Yes.
Translito?
Reluctantly, yes.
In addition to that, we have the site plan recreation fee fines for the town Marlboro Planning Board. Whereas the Marlboro Planning Board has reviewed the site plan application known as Dock Road with respect to real property located at 103 to 137 Dock Road in the town of Marlboro, Member Lamella offered the following resolution, which was seconded by Member Transalito. It is hereby resolved that the planning board make the following fines pursuant to section 2774 of the town law. Based on the present and anticipated future need for park and recreational opportunities in the town of Marlboro, into which the future population of the site plan will contribute, parkland should be created as a condition of the approval of the site plan. However, suitable park of adequate size to meet the above requirement cannot be properly located within the proposed project site. Accordingly, it's appropriate that in lieu of providing parkland, the project sponsors renders to the town payment of a recreation fee to be determined in accordance with prevailing schedule established for that proposed for the town of Marlboro. The site plan known as Dock Road resulted in 106 total units for a total of $212,000 in recreation fees, whereupon the following vote was taken. Chairman Brand? Yes. Callan?
Yes.
Lamella?
Yes.
Jennison?
Yes.
Lanzetta?
Yes.
Rivera?
Yes.
Transalito?
Yes.
The end. I believe you're all set for this evening.
We didn't see the copy of that, we, you forwarded us a copy of that,
I'm sure our attorney will so. Yes. The back fee or the?
red fee. I hadn't seen that one.
Yeah. We'll definitely get that. Great. Anything else from me this evening? No? All right. We are adjourned.